the essential participant here. Plenty of time. Okay. And then Charlie's going to go first, and then I'll jump in at some point. Thrilled to do it. Took some doing. Setup was kind of funny. Charlie and I both had the intuition that you would go in the middle, and that's yours, I see. We have only two. Oh, yours is down there. Which those wiser people who organize these things said, if you do that, then he'll be ping pong. It's very smart. This is the seat normally for the. I started to sit there, and they said, no, scoot over. I was like, okay, then it makes it more conversational. I totally understand. How are you feeling? You did tell me that, and I've taken it to heart, and it makes me feel better. And actually, I feel like the suggestion there being that if you don't feel that, then something's wrong. Like you still need the. I hate to, yeah. Really? Interesting. Yeah, it does feel very strange. Yeah. I don't like interviews of any kind. Right. Yes, this is how I feel about all interviews. Yeah, no, this is true. I agreed to do an interview with a Chinese television station when I was in Washington, D.C., and I'd asked about them. People here said, no, they're legit. CCTV is called. And so then I should do some background on them as I'm in the taxi from the airport. I Google them. What is CCTV? This is the mainline broadcast viewership of like 1.3 billion.
Good afternoon, everyone.
Straighten my tie.
Excuse me. I'm Melanie Dunshee, Assistant Dean for Library Services here at the Duke Law School, and I'd like to welcome everyone to this discussion and celebration of Jeff Powell's just published book, Targeting Americans, The Constitutionality of the U.S. Drone War, with this lovely cover here. The Goodson Library supports our faculty in many ways in creating scholarship and making it widely available, but we are especially pleased to organize these regular events to celebrate and learn more about their faculty-authored monographs. And I'd like to thank Guy Charles for this idea and asking us to do this. I also want to thank our joint sponsors for this event, the Center on Law, Ethics, and National Security, and the Office of the Dean. I'm just going to give quick introductions, as I think there are some visitors from outside the law school today that might not be familiar with our faculty. Professor H. Jefferson Powell, which is a very fun name to say for me, is a prolific and esteemed constitutional scholar with over a dozen books along with an abundance of articles published. He also has deep practical experience and expertise in constitutional issues, most recently serving as Deputy Assistant Attorney General in the Department of Justice's Office of Legal Counsel. He has briefed and argued cases in both federal and state courts, including the Supreme Court of the United States. In conversation with Professor Powell today are our wonderful and generous colleagues, Professors Charles Dunlap and Joseph Blocher. They are perfectly chosen for this conversation on this topic. As you will find, they both have a lot of background and expertise themselves. Professor Dunlap joined the Duke faculty in 2010 and is the executive director of the Center on Law, Ethics and National Security. He retired after a 34-year career in the U.S. Air Force, where he last served as Deputy Judge Advocate General at the rank of Major General. And as an aside, you may be interested to know he is a Villanova alum.
And I did watch the game. And I did order hats.
Good. A prolific author and accomplished public speaker, Dunlap's commentary on a wide variety of national security topics, including use of drones, has been published in leading journals, newspapers, and other sources. Professor Blocher joined the law faculty in 2009. A valued and generous colleague, he also received the Distinguished Teaching Award in 2012. He has, in a short time, produced an extensive publication record and has a strong reputation on federal and state constitutional issues. And finally, one more note. If after listening to this or at any time, if you're interested in purchasing the book, Oxford University Press, the publisher, has kindly given us a flyer with a 25% discount on buying the book. So if you'd like one of these after the presentation, we'll have them available to you. And I'm just...
Thank you, Melanie.
Well, Jeff, I think I'll dive in and start off the conversation. I do have a couple questions for you, but first I want to say, quite honestly, I got this book with the idea that I wasn't going to like it, whatever it said, because most of the stuff that I've read on drones, especially coming from the academic environment, and that's not really your background, but has been ill-informed, and they make what I tell my students the big mistake. In other words, they'll try to get into too much about the technical aspects of drones and so forth, and they try to write about it in a very elliptical way that has this veneer of knowledge that they really don't have. I think that what you did, and it's early in the book, and I'm not sure how much it's been discussed, is you talk about it, it's really about the use of force against Americans, and the platform is not really the issue. It's the constitutionality of the use of force. But from a very practical point of view, one of the things I really, really liked about your book was this. Which means people are actually going to read it. It's very readable. And it's written in a way that it's accessible to anybody, including the non-constitutional, not just the non-constitutional law scholar, but it's accessible to the general public, which is what I think will be very important. And another thing that I personally really liked about the book was it's something that I tell my students in national security law. If you want to understand things like constitutional law, administrative law, and so forth, sometimes it's better to look at it in the context of national security law, simply because we can all wrap our arms around the idea of a drone and then the killing of an American. You're not starting off with some very convoluted matter of constitutional law which would bring in. And what I think the book is most valuable for is how you go through a way of thinking about the Constitution. And I'll tell you, I learned a lot. And if you're thinking about taking national security law next year, I would advise you to read this over the summer, because I got a feeling it may be instrumental or key to your success in the course. Allow me to say that. But really, I think that is the biggest service of this, is that you're projecting on a very important topical issue the ability for anyone to understand constitutional analysis. And you have plenty of footnotes in there for the scholar who wants more, and then you have an appendix, which is, in the appendix, there you get really heavy-duty scholar-type stuff. So there's something for everybody in here. Let me ask you just one question, get it started. Why'd you write the book?
I wrote the book because I developed a sense that people were in fact not doing what you and I agree they ought to be doing, which is thinking about it in the right framework. There was this inside the Beltway, but that's not even the right term, inside the hothouse of government, national security type folks, not all of them well informed, unfortunately, who were debating issues in what at least purported to be very technical ways. And then there was a largely uninformed public debate. And the public debate is vital because this is what the United States government is doing when it targets Americans or indeed anyone else. It's doing on behalf of the entire political community, and we ought to understand it because it's being done in our name. And so I had the sense that somehow we need to avoid the mistake of the over-technical, and I think oftentimes I agree with much of what you said, critical about that discussion, but also bring down to earth in a serious way what are the basic constitutional questions. And I've spent a lot of time in government, and so this perception that we had an important debate which wasn't being well served is really what drove the book.
One of the other big mistakes that you didn't make, in my judgment, that I see so often in others is that you pretty clearly delineate a couple things. One is the difference between authority under domestic law and international law. And you, except in certain aspects, you really don't try to engage that larger international law debate. And I've seen that go wrong. Even when people have some good thoughts about drones, it goes wrong when they try to understand international law without the depth. And the other thing is, you don't, you address very directly some of the tough arguments, and you don't qualify your opinions unnecessarily. And I think that that's going to make this book have the moniker provocative. But I think it's something that we need to see more of in academia. Because you read so much of this stuff, and at the end of the time, you're trying to figure out, well, what does he really mean? And you have to kind of glean it through these. Did you think about that as you were writing it?
Oh, absolutely. It's an academic instinct to qualify and leave yourself an out. The Supreme Court occasionally does that itself. And I did not want to do that. My objective was to put my cards on the table, to take positions, to make it clear, as you know I do on a couple of issues, to make it clear when I'm very uncertain about my conclusion, but to reach a conclusion. And part of that, I think, is my government service. You don't have the option if you're advising the policymakers, well, you know, you could say this or you could say that, and no, they want to know, okay, you telling me it's lawful or it's not lawful? And if you're saying not lawful, why not? You have to come down to a responsible decision. And I think that background experience is what drives the book on that matter.
And the reason that's really in the forefront of my mind, I don't know if anybody's seen the movie Eye in the Sky. Has anybody seen that? And one of the things, and it's pretty realistic in a lot of ways, but one of the things that it would not reflect my own experience is the hand-wringing by some of the lawyers involved, especially at the military level. And I do think it's important that, you know, people, you know, take positions and in a way that's understandable to those who may not be into academia as much. Now, you have taken some really controversial positions, and I think Joseph is much better. Professor Blocher's forgotten more about constitutional law than I ever knew, I have to admit. He's always so nice to me when I make some pronunciation. Years ago, I wrote an article about the Second Amendment. Believe me, he's the world's expert on Second Amendment constitutional law. And he always treats my article as if it's like a legitimate academic effort.
It is, it's fantastic. And everyone here should read it, by the way.
But the thing about it, and what I'm hoping that you might inform us, Jeff took a really controversial position about the application, or rather the non-application of due process to these decisions. I think it's eminently correct, but why am I right?
Well, maybe the place to start actually
why is he
is
right?
How you reach the conclusion. Because one of the things that, so when I picked up the book, so I picked the book up as a book about constitutional interpretation, which it very much is. And this is, for those of you who are even not particularly drawn, as you should be, to the subject matter, this is a book about, and there's literally a chapter called How to Think Constitutionally. And you say very clearly in the book, in order to evaluate whether it was constitutional for the United States to kill an American citizen, Anwar al-Awlaki, without trial, using a drone strike, one must first know what it means to think constitutionally, which is it's sort of true statement, but a tough one to unpack. But I wonder if you could take a crack at what you mean by thinking constitutionally.
Well, I appreciate that, Joseph. Let me try. Charlie made a point that's very important, and that Americans, and this goes all the way back to de Tocqueville or before, Americans often get this wrong. Constitutional law is one thing, but not everything. If you get advice from a constitutional lawyer that's sound advice, it's going to be about the particular issue of constitutional law that you ask her about. It's not going to tell you whether the action conforms with international law. It's not even necessarily going to tell you whether it conforms with all forms of domestic law. It's certainly not going to tell you if the action is wise or in the best interest of the United States in terms of national security or any other way, or whether it's moral or just. It's going to tell you one particular thing, and when policymakers in the executive or the legislative branch make decisions, they've got to be thinking about a lot of things besides constitutional law. So one of the things that the book is trying to do throughout is say, look, this is an important part of the puzzle in American national security thinking and in American thinking generally. It's only part of it. And part of what it does is serve other kinds of thinking, including the ultimate decisions, as, for example, whether to kill Mr. al-Awlaki. When you think about constitutional matters, then, you're thinking about a question of law. It is law, and I say in the appendix that Charlie referred to, I think it's a kind of law that is continuous with all the other kinds of law that we ordinarily deal with. It's not some esoteric special thing, but it is a particular kind of law in another sense, and it involves a particular kind of thinking. There's a tradition of constitutional thinking that goes back to John Marshall and before. There's a particular way of identifying with some precision what the question is, asking yourself, are we talking about the federal government? Okay, you can't do anything unless the Constitution authorizes it. Where do you find that authority? Having established that, then asking yourself, well, is there some reason why, although the Constitution says, yes, you may speak to this, it also says, but don't do this or that. And of course, the Due Process Clause is an example of that. The government may be able, in fact, the Due Process Clause language is often thought to suggest, you've questioned that the government can sometimes take your life, but it can't do so willy-nilly or forever or under any circumstances. It must afford you due process of law where that prohibition or requirement applies. So the book tries to lay out a traditional approach and therefore avoid, for the purposes of the book, a lot of current day debates that are very interesting, that many people find very important, but that prevent you from getting to the actual question. So, for example, a big group of people in the academy, but also some of them sit on courts, believe that constitutional law is a matter of figuring out the original meaning of the Constitution and applying that and sticking to it. That's not the traditional view, in my judgment. Another group of people think that constitutional law is a matter of the living Constitution, by which at least some of those folks seem to mean whatever's the best answer in the judgment of the person giving the answer. That's not the traditional view either. So what the book is trying to do is lay out a picture of how it is that constitutional lawyers have traditionally done their job, that I think is different than the current methodological hot-button debates, and that then enables us to actually address in this case, a specific and very big-ticket question. The United States government, after spending a couple of years thinking about it, deliberately killed a United States citizen, Mr. Anwar al-Awlaki. That's a little startling, or ought to be. Was it justified constitutionally? And remember, if it was, I don't think that means we should have done it. That's merely to establish a predicate, a necessary prerequisite to doing it. There are other questions as well.
And the two big, I just want to elaborate one thing in case anybody sort of missed it, because it was subtle in your answer, is that in this book and elsewhere, you often evaluate constitutional problems through those two lenses. Is there an authorization? Is the authorization overridden by a prohibition? Any of you who are in constitutional law, this is a good way often to approach constitutional problems. And you have, as Charlie has suggested, some potentially controversial conclusions, both with regard to the authorization here and to the prohibition. But let me slip in one more question here, which is whether that style of constitutional reasoning that you've described is really available to the government lawyers, let's say, who have to make these decisions on the fly, under pressure, by people who have on their minds the ethical, moral, and other considerations. And you're in a good position to answer this, being both a scholar of the executive branch and government lawyers, and their interpretations of the Constitution, and, as Melanie mentioned, someone who has served both, I think, as Melanie said, as Deputy Solicitor General, as Melanie said, I think, as an Attorney General in OLC, the Obama administration, but also Deputy Solicitor General in the Clinton administration as well. Is this the kind of reasoning that you need a book to do and you have to be a scholar, or that is accessible generally?
Well, I think the bottom line answer is you don't have to be a scholar. The role of scholars, and this is why Charlie's point about come to conclusions, and that's a valuable thing for scholars to do, that's one reason that's important. Scholars are able to sit back and think at leisure and with some ability to reflect. When they do so, they provide a great service, providing they actually bring their reflection and the thought and the time they have to think to bear on specific issues. As Charlie knows, having also served in the government for much longer than I, you have to sometimes you need to give advice under conditions that are not reflective very much, very short term, and yet answers are needed. But the answer is, to your question, is yes, it is available. It's available because it's a basic style of thinking. It's one that law schools ought to be inculcating in people, and that the practices of law, I think, do inculcate in people. A lot of people who wouldn't use the language I use instinctively use it because they're good lawyers. They understand how to think through the problems. So yes, I think it's available. And it is part of what makes it available is it actually connects to the problems that the policymaker brings you and says, can we do this? Is this lawful?
This does remind me of something I wanted to ask you about to see if you saw it in government as well. And as you say, I think the great value that the academy can bring is building what I call the intellectual infrastructure, because when you're actually executing and making decisions, you don't have the time to be as reflective. So that's why you have to write a book that people are going to actually read. And there's an awful lot of constitutional law texts that nobody other than scholars are going to read. But the other thing is, and I'm wondering if you saw this, is sometimes in government, especially today, and you allude to this, I think, towards the end of the book, or maybe it's in the appendix, legality sometimes becomes part of it's a good idea. And people confuse the two. And somehow it seems to get a better, if some lawyer says it's okay. What's your reaction to that, and how might this book help work through that issue, if indeed it is an issue?
Absolutely. People oftentimes think of the problem as, well, you know what you want to do, and therefore that influences the lawyer's advice about legality. That's obviously a problem, or that can be a risk or a temptation. But it works the other way around, as you just pointed out. The fact that the lawyer says, oh, yeah, that's constitutional or that's lawful, then can play into both the lawyer and the policymaker's thinking in terms of, well, it's lawful, let's do it. Well, you haven't learned whether you should do it or not when the lawyer says it's lawful. You've merely learned that you can do it lawfully. And in fact, you've only learned, if it's a constitutional law advice that you've gotten, you've only learned that you can do it constitutionally in our system. You haven't learned, for example, what international law says. The reason why I think it's important for the people who've got the time to do it and to try to communicate a sort of reflective thought on these matters is because when you do, and if you grasp and have some sense about how it is that one tackles constitutional problems generally, you've got a good chance of avoiding the kind of mistake that I think, for example, and this is highly controversial, I think has beset the administration's lawyers on this very matter. The issue, I was served in this administration, but I served after the Justice Department rendered advice on the killing of Mr. al-Awlaki. In my judgment, highly controversial. What we know of that advice reflects not simply I kind of probably didn't have enough time to sit and think, but a failure to keep separate things and to think things through so that yes, there are international law questions. Yes, there are questions about the role of the congressional authorization for the use of military force. Yes, you have to ask yourself about the Due Process Clause, but these are separate questions. Don't muddle them together.
I completely agree. What Professor Powell's talking about is he goes through the OLC memo in some detail. And it's exactly, I won't say exactly, but it's much exactly the wrong way to write a memo for decision makers because it muddles too many things. One thing that becomes important in your book is history, and particularly Civil War history. How important is that in your constitutional analysis, and where does that fit in? Because it seems like that's a factor, but it's not the only factor.
Exactly right. Look, there are a number of things that a responsible constitutional lawyer ought to be looking at when she addresses a question like this. Obviously, she's going to look at Supreme Court decisions. That's the bread and butter of constitutional lawyers. It was in the beginning, and it is today, notwithstanding all the methodological debates. She also is going to be looking, of course, if she's doing her job well, she's going to somehow factor in what is the court missing? What is the court not addressed? I mean, the question in the end is not, the final question is not the court's views or the views of 5 justices, but rather, what does the Constitution properly understood command or prohibit? But she's also, if she's responsible, going to look at our constitutional history, not just for how have people done things, not just for specific judicial decisions, but for what that history tells us about the Republic's understanding of what is, after all, the Republic's Constitution, not the judges. And that means you're going to look very carefully at political practice, and the sound constitutional advice on a matter like this is going to be advice that takes account of and makes sense of our constitutional history. So that, for example, just to use what is, from my perspective, the most vivid thing of this sort in this connection, the United States government deliberately killed 6 figures worth of American citizens between 1861 and 1865. It did not give them trials. It did not give them anything that I think can possibly be deemed to be due process of law. It killed them because they were Confederate soldiers. Now, from the standpoint of the U.S. government, and I agree with its judgment then, they were U.S. citizens engaged in war against the United States. But they were U.S. citizens nonetheless. Did that violate the Due Process Clause? If your view of constitutional law then, and if you hold the view that I think is implicit in people who insist due process applies across the board always, I think your view now, you're saying in essence that Jefferson Davis was right on the major constitutional issue. The Civil War was not the United States government responding to those acting unlawfully to overthrow the government in part of the territory of the United States. It was the War of Northern Aggression, an expression that where I come from was sometimes used. Well, I don't think that's right. And you don't make sense of the history of the United States, and in particular of constitutional history, if you end up agreeing with Jefferson Davis and disagreeing with Abraham Lincoln on that fundamental matter. So it's an obligation and not just a sort of gloss on the lawyer talk when you say to yourself, okay, is my advice consonant with the best understanding of our constitutional history?
Maybe since Charlie sort of put on the table the due process argument, maybe we'll do that one first and come back and talk about your argument on the authorization. So the due process is the potential prohibition that many people at least have suggested constitutionally should have stopped the U.S. government from killing Anwar al-Awlaki, a U.S. citizen, with a drone without trial. And your conclusion in that is that the due process clause was not the obstacle here. And this is one of, I would imagine, probably the most controversial conclusion. Certainly one doesn't want to be on the side of Jefferson Davis, but you put yourself on the other side of the Obama administration, among others, right? The president has said, among other things, and this is just reading a quote, I think from 2013, "For the record, I do not believe it would be constitutional for the government to target and kill any U.S. citizen with a drone or with a shotgun without due process. Is the president's quote there missing the question, or are you in direct disagreement with the administration on that?
The president's lawyers qualified their due process advice by lines like, assuming the due process applies. And the president was speaking publicly, and I wouldn't hold a sitting president to precision in legal argument in that kind of context. But if the president meant what he said, the president is simply flatly wrong. Let me give you in a nutshell why. I've just given you the first, and I think very powerful point. That viewpoint is inconsistent with our political practice. It renders Davis right and Lincoln wrong on a crucial part of the constitutional issues raised by the Civil War. Secondly, it's inconsistent, the view that due process applies at all is inconsistent with a long line of Supreme Court cases. They begin back when John Marshall was Chief Justice, and they go up at least to Ex parte Quirin during World War II. Supreme Court decisions don't have cell dates. None of these decisions have even been questioned on this matter. I don't see any reason to think that they aren't the current black letter law that I, as a district judge, if I were one, would have to follow. But does the court have it right? Maybe the court had it wrong, and maybe the Civil War is, well, we just can't talk about it. We obviously can't say Davis is right, but we don't want to say that Lincoln is right either. We're just going to put that to one side. Is there some sense in which this makes sense of our system? And I'll give you two reasons why, in my view, the Due Process Clause simply doesn't apply in the circumstance of the targeted killing of an American citizen in the current struggle against the perpetrators of 9/11 and their allies. Two reasons. Number one, as a matter of principle, the Due Process Clause, like other parts of the Constitution that impose prohibitions on government, imposes those prohibitions on government when it acts in governance, when it is in fact governing the community, primarily we the people, but also those who are within the community. They are irrelevant in principle when the government acts against the outside world. Now, one reason that people get upset about that is because they think, oh, you're saying anything goes. Not at all. Number one, the executive branch and the Congress have to be authorized to do something, and the grants of authority to the President and Congress, broad as they are in national security, are not unlimited. So there may be, and I think there are probably, significant limits that at some point might kick in as the President and Congress together, let's assume, are using targeted killing as a method of fighting external enemies. Secondly, the Constitution, I've already said this, the Constitution is not the only normative set of concerns. The Constitution, I believe, clearly presupposes the United States as a member of the community of nations, and therefore there is some role, some very important role for international law. If you have something that may be domestically lawful and constitutional, it has to be constitutional to be lawful domestically, but violates international law, then that should raise a question. That the United States will be a lawbreaker internationally if it acts in that situation. And of course, there are other concerns. Some people, including people qualified as I am not to make strategic decisions, think that the targeted killing of Mr. al-Awlaki was a very bad idea. Strategically self-defeating, at least the overall program is. If that's so, then regardless of whether it's lawful, we ought not to be doing it. And then there's the moral question. If people can't distinguish what we're doing when we kill someone like Mr. al-Awlaki for murder, that's a kind of moral judgment that we ought to be paying attention to. And if we, the people, can't draw the distinction, if it feels like murder, seems like murder, well, we're not in the business. The Constitution presupposes we're not in the business of murdering people. I don't think that's what it is, but that's something we ought to be thinking about. All right, so that's one reason why, even in principle, I don't think the Due Process Clause applies. The other is, okay, let's assume it does. Let's try to think through how we're going to apply due process to someone who is the al-Qaeda equivalent of a general in the enemy forces, who is not within our reach. He can't be arrested. He is actively carrying out his duties in his system for his not a nation, but for the belligerent that he is serving? How are we going to give him, do we want to give him notice? Are we going to give him, no, we're going to send him a complaint? I don't think so. Are we going to listen to him explain the reasons why we ought not do it? No, we're not going to do that. No one's ever proposed we do that. That's not quite true. That's not what the administration does. No one is advocating within the administration on behalf of Mr. al-Awlaki why we ought not to kill him. And the decision, okay, do we have a good enough reason? Are we convinced he's actually the person we think he is, that he's the equivalent of a general in an enemy army? That decision is not being made by a neutral decision maker. So we don't have notice. We don't have the opportunity to be heard on the part of the target. We don't have a neutral decision maker. The core basic elements of procedural due process. Now, when I was writing the book, and I got a lot of pushback on this, including from Philip Bobbitt, the very distinguished national security and constitutional lawyer who wrote the foreword to the book. Professor Bobbitt's argument to me, put very forcefully, was, no, the due process clause applies, and the due process, the only due process due, is the fact that Congress authorized the killing. With respect to Professor Bobbitt, that is, if you want to get technical, a substantive due process argument. It says that this is not something unthinkably beyond what American government can do. It has nothing to do with what procedural due process is, which is enabling someone who the government wants to harm to have a chance to say, you're wrong, don't harm me, and have that heard by someone who's not part of the decisional process. Now, the way the administration's lawyers analyze this, they said, well, no, we're providing procedural due process because we've got an internal executive branch process. We don't just kill people willy-nilly. We do a lot of hard thinking. I'm glad. That's great. If the administration is following the procedures that OLC talks about in its memos, that's excellent. That shows, well, part of it's excellent. It shows a concern that we do things wisely and so on. But it's part of the group in government that wants to kill somebody, listening to its own reasoning and saying, okay, I'm convinced by my reasoning. That is not procedural due process. And when you say it is, which the administration lawyers ultimately do, and many people outside government want to say that as well, when you say it is, you've made the mistake that Justice Jackson identified in the Korematsu case in World War II. That's the Japanese-American internment camp decision. Jackson dissents and he says, when you authorize something, you say it's lawful and constitutional, you have left a loaded gun lying around. You've authorized something that on its face of it's clearly not constitutional, and you don't know when that alters that legal reasoning that's led you to this conclusion will take you places that you currently don't want to go and ought not go. Same thing here. Once we decide that procedural due process is satisfied without notice, without an opportunity to be heard, without a neutral decision maker, I think there's nothing left. And I certainly don't think we ought to be calling it procedural due process. And one final thought. I'm running on, but let me just say one final thought. Why are we so eager to be able to say something like, well, yes, we gave him due process, even though, of course, we didn't listen to a word he said and we didn't ask a neutral decision maker to judge. Why are we eager to do that? We're eager to do it because we're uneasy. We're uneasy about things that I think are legally irrelevant, like the fact that the way we killed him was by using an unmanned aerial vehicle as opposed to more conventional or traditional or older means. Maybe we're uneasy because we have moral concerns. Those are serious. They ought to be taken into account. They're not legal concerns. And maybe it's because we'd prefer not to think about what it is we're doing when we fight a war. When we fight a war, we kill people. If you're a pacifist, you say no to that, and I respect that. I'm not a pacifist. And the U.S. Constitution is not a pacifist document. We kill people. That's an ugly business. It is, from many perspectives, mine included, and for certain reasons, a very unhappy business. It's a necessary business, and that's the question that constitutional law addresses, not this desire to feel better by hiding behind, oh yes, we gave him due process. That makes it all seem like clean cuffs. No, it's war, and that's what war involves.
I found that argument, your argument, to be very powerful, and I have to admit that prior to reading your book, I was a Bobbatier, for want of a better term, and I do think, and bad on me, I didn't think hard enough about the difference between procedural due process and substantive due process, and I think that's a great strength of your book. In fact, I think one of the things that I think lawyers and law students can take away from your book, in addition to everything we've talked about, it's just a way of thinking about problems, about legal problems, and the way you have to pull them apart, maybe more than the easy, superficial. And you have to take your feelings out of that part of the analysis. I think feelings, to the extent they represent moral qualms or whatever, do come back in at some point in the is it a good idea portion. But I think in terms of analyzing problems, it's very illuminating. Did you?
Charlie, can I just interrupt for just 1 second? I want to underline something that you're saying. Students, and I probably my students included, oftentimes view doctrine, the sort of the rules and patterns of analysis and so on, as if they were problems, and they are problems, you got to learn them. But they're actually tools towards good, responsible legal advice, towards good, responsible legal conclusions. They help you figure out, okay, exactly what is it that I'm trying to decide? What is the question in this particular instance with respect to this particular aspect of the problem? They help you do that. They make your decisions not easier, but rather more focused and more responsible. And that's why doctrine is not just a hindrance, it's a help in thinking through these kinds of issues. Sorry.
Well, I was just going to say, and just so people don't walk out with the wrong idea, I don't hear you as suggesting that that's the only part of the analysis. As lawyers, when you look at the ABA code, Rule 2.1, it talks about the lawyer as a counselor. You bring in these other factors. But I think it's very important to decision makers that they get this clarity. And I found, in my own experience, senior people, especially towards the end of my career, would come to me with things that really weren't legal problems. They're trying to tap into the unique way lawyers analyze problems. And that's what I think is valuable about this discussion. But we do want to open it up to some Q&A. But before, Joseph, could you ask the smart question about the AUMF?
I have a smart one, but I can ask a question about the AUMF. So we've been talking really about Professor Powell's somewhat perhaps controversial, and we'll certainly hope for questions on this, conclusion about really the lack of at least a due process prohibition. You'd say the same thing of anything in the Bill of Rights. If the government is validly exercising its war powers, then these simply do not apply. And that puts a lot of pressure on the authorization question, of course, whether the government is validly exercising its powers. So I can ask a question about the AUMF. For those who aren't familiar, the AUMF was a law passed arguably hurriedly after September 11th, which, among other things, authorizes the president to exercise power against such people as he decides were connected with, I guess, the attack on September 11th. Has no time limit. There's no sunset clause in it. Has no geographic limitation. Theoretically applies anywhere in the globe. And that can be read very broadly, as I think many people have and as you do. But if I were to ask a hard question about it, I'd say this, is that with regard to something so extraordinary as targeting and killing an American citizen without trial, should we at least there require something like a clear statement rule in the AUMF? And it may be one thing to say, okay, sure, you can attack Al-Qaeda, and that includes ISIS or ISIL, but surely, just as a matter of constitutional avoidance, we should be concerned about this kind of a thing for precisely the reasons that you've identified earlier. That might not be what Congress intended. And on this is a page I'd flipped to earlier when I was thinking about your earlier comments. I can invoke Jefferson, another president who I think you're on the other side of on this issue. Was Jefferson, discussing the Article I powers, says, to take a single step beyond the boundaries thus specially drawn around the powers of Congress is to take possession of a boundless field of power. And the AUMF, if you read it to authorize this, seems to be just the blank check. Should we be at least more hesitant to read it the way you do?
Okay, that's great, Joseph. And it's a tough and important question. As is oftentimes the case, and I'm sure you both have this experience, I sometimes get asked by journalists questions about what they think of as a big-ticket constitutional question. Is the president entitled to do the things he's doing with respect to immigration? And I say, look, I don't know any immigration law. I would have to find out a lot of stuff about what Congress has said before I can tell you, A, if the president is acting consistently with the statute, and B, if the statute itself is constitutional. The AUMF authorizes the president to go after people involved, essentially, oversimplifying, involved in 9/11. That's not a blank check. It doesn't have a time limit, although I think there may be, and to my interest, I've talked to a group of federal judges where their overwhelming sense was that makes some sense. I think there may be a sort of expiration that's built into what the AUMF says, which is that the president's to act in response to 9/11 against the perpetrators of 9/11 and essentially to ensure that 9/11 does not occur again. It's not a blank check. You're right, there's no geographic limit, but it defines who the enemy is. It's not a declaration of war on terrorism, if there could be such a thing. The enemies are those who are in some genuine sense connected to 9/11 and maybe after the fact, but are genuinely connected to 9/11. As Charlie knows, and I have this experience a lot as well, people in the executive take those kinds of things very seriously. There's a lot of cynicism in public discourse about that, but the cynicism is usually misplaced. When you have a question such as, okay, we've got authority to act with respect to X and Y, but it sure would be nice if we could act about Z as well. When the lawyers are doing their job, and overwhelmingly I think executive branch lawyers, in uniform and not, are trying to do their jobs well, you spend a lot of time saying to yourself, okay, does Z actually fit in with the things that are clear, X and Y? So I think that congressional limitation, this is authorization to use military force against certain people who use the tools of international terrorism, not against just anybody who might. That's a limitation as well. And then the AUMF was, of course, as you say, enacted in haste in a situation of crisis, but it was enacted with some attention to what Congress said. The administration, the Bush administration, asked for something very close to a blank check. Congress declined to do that, notwithstanding the situation. That's an extraordinary action on the part of Congress. I think we honor Congress and the system that we have by taking seriously what it said. That means, on the one hand, a very broad sense about who may be gone after, but not an unlimited sense of who the enemy is. And on the other hand, Congress says, use all necessary and appropriate means. All right? I think that language naturally lends itself to, and this is supported by the Hamdi detention case, that Congress meant at the very least to be saying, use those tools of military force that are traditional under the laws of armed conflict. The enemy, in a situation of lawful armed conflict, is the lawful object of deadly force. Nothing in either international humanitarian law or in U.S. domestic law says that somehow changes because the enemy happens to be a U.S. citizen. That being the case, I think that it's not a stretch to see Mr. al-Awlaki, a high-ranking member of al-Qaeda, or al-Qaeda subsidiary, was precisely within the group of people targeted. I agree it's extremely important, although that may be a political rather than legal judgment, to know that Congress has authorized the killing not just of enemies, but of Americans who are enemies. But I think it clearly did so in this statute.
Let's open it up to, I have about 1,000 more questions, but let's open it up to some Q&A. Jay?
I'm curious, are there other constitutional rights that are suspended for someone who has taken up arms against the United States or is in this position? Like, can we search their property?
None of them are suspended. No, excuse me. None of them are suspended. That's not the argument. If the government wishes to proceed against, had wished to proceed against Mr. al-Awlaki as the traitor that apparently he was, then it needed to, consistent with the Fourth Amendment, arrest him, which might, of course, can involve deadly force, but it was bound by the Fourth Amendment. It would have been required to bring him to have him properly indicted, to bring him to proper trial, to have him convicted before it could lawfully harm him further than holding him for the process of trying him. All of his constitutional rights, unless there's some limitation based on where he was, and I'm willing to just waive that, all of his constitutional rights remain in full force if the government is acting in its capacity as the government. It's governing Mr. al-Awlaki as part of we the people. Where Mr. al-Awlaki is acting as a member of an enemy belligerent, a foreign enemy, an enemy that is attempting to, within its capacity, harm the republic, then the government uses something it can't use against citizens when it governs them. It's using the war powers. And the due process clause, like the rest of the Bill of Rights, is not suspended. It simply doesn't apply.
George?
You people have raised a number of issues. One, of course, is that just calling something legal doesn't necessarily mean it is legal in a bigger sense, in a sense international law or other sorts of factors. And also there's certain amorphous qualities. For example, in my lifetime, we were fighting against, quote, communism. And that justified giving machine guns that would kill Allende. The biggest mistake that the United States has made, I think, in the last 60 or 70 years was overthrowing the Mossadegh regime in Iran, which many people also think about. The point is, there's a certain amorphousness to what's going on, and people just do things. Now, on the subject that you people are talking about, you talked about drone killings of Americans and maybe non-Americans out there, in a sense, the so-called enemy. Now you run into a distinction. We are part of a convention which prohibits the use of torture, not only against Americans, but also about people who happen to be captured by the United States forces. Well, if you can, supposing you can't use drones to kill Americans, but you can use it against people who are not Americans or part of ISIS in some amorphous sense of, quote, communist, like Mossadegh was accused of being, and that sort of thing. So you get sort of, to my mind, sort of a half-assed type of situation. You could kill the person, but you can't torture him to get information. And it indicates that there are a lot of things that just can't be governed by law. They require prudence and decent people to be in charge. If you don't have people who are prudent and decent, there's not much you can do, because people are going to use any kind of rationale to accomplish their goals and their ends.
Well, let me throw this to you, Jeff. I think what George is talking about is issues of international law versus constitutional law and the war powers versus the governing powers. Do you have any observations on that?
Well, I mean, the very last sentence in the book strongly endorses George's last point, which is that the ultimate determinant of whether the United States government acts decently and humanely is the decency and humanity of the society that the government serves. And so that's a bigger normative issue than even the Constitution or international law, either one. That said, George, I don't really understand fully, I think, the problem you're perceiving. The community of nations has always recognized, has never been pacifist, has always recognized the lawfulness under certain circumstances of killing an enemy. That doesn't at all say that international law has recognized or should recognize torturing the person. Great, George, absolutely. Somebody wittily said that, when we declare war on abstractions, it never works out well. And I think that person cited the war on drugs. You may or not agree or not, I actually would. Where we're going to succeed is not on drugs, on communism, on terrorism, it's on a specific enemy. The authorization for the use of military force is against a specific enemy, defined in ways that are broad, in part because we didn't know fully, if indeed we know now fully, who the enemy was. But it's defined in ways that are not amorphous, but rather precise enough for the government work that we need to do.
And I think you do say at the end of the book, when you talk about the AMF and the implication of the temporal aspect of it, at some point, those designated in the AUMF are going to be so attenuated that the AUMF itself will be maybe still extant, but not applicable to particular use of force, in which case we're back to phase one, I think, where we're looking at the president's Article 2 powers, which would have implications in international law because it might obviate the possibility of status-based targeting. Let's see if we have a student with a question. Rick?
So you talked about how the due process clause just doesn't apply in the first place when you're talking about, an enemy, when the government is not acting in its capacity as a government, but as a sort of, I suppose, international actor or something like that. But I guess my question is, what's the authority for the idea that there's this bifurcation between governance and then a different set of rules that are not constitutionally explicit in other aspects?
About 15 Supreme Court cases.
Matt?
Thank you, Jeff, for this. I look forward to reading the book. I haven't done that. So let me just push back a little bit on the due process argument.
The book has other things in it besides the due process clause.
Yeah, but I think it's an important argument, and I think people who think there's a due process issue are not necessarily just in the grip of emotion. I mean, as I'm sure you know, if you look generally at procedure due process doctrine, not substantive due process doctrine, I agree that distinction is really important. There's a lot of case law that suggests that targeting is important in a different kind of way. So, for example, if the SEC were to pass a law or a rule which says no one may provide financial planning advice, for a fee except if he or she has certain educational qualifications, in theory that raises SDP issues, although it's subject to rational-based review, but does not raise procedure due process issues at all. On the other hand, if the SEC issues a specific order that says Matt Adler may not provide financial planning advice, then that raises a procedure due process claim. So that distinction between some kind of general law or general governmental rule that imposes burdens as opposed to a targeted one, sort of formally specific one that picks out a person by name, that only the latter raises PDP issues, of course, goes back to Holmes's opinion in Bimetallic, right? So Holmes in Bimetallic says when the state of Colorado, by general rule, imposes the valuation of taxable property in Denver, no procedure due process problem there. Distinguishing Londoner, where Denver itself had increased the valuation of property in a district within Denver by specific exaction on particular piece of property. So that, we can talk more about it, but that, it seems to me, as a legal matter, not as an emotional matter or a moral matter, but it is exactly the distinction between Bimetallic on the one hand and Londoner on the other, that answers the claim that if you think the targeting of Milwaukee raises a procedure due process problem, then you must be with Jefferson Davis, right? Lincoln's response is, well, no, it's different to engage in actions which predictably will kill tens, hundreds of thousands of people who we know under general description, namely people who were soldiers in the Confederate States, as opposed to singling someone out by name. And that distinction, I don't think it's right or wrong, but that has been a key part of procedure due process doctrine since Bimetallic.
Do we see, number one, I'm not sure everyone who's killed in the Civil War, people really knew their status. There's a lot of, but is this a different?
We can talk the distinction between taking an action or passing a rule which imposes a burden on a class of people or predictably causes harm to a class of people, as opposed to singling out someone by name for burden, and specifically for a burden that constitutes a deprivation of property or liberty, is itself, for a century, part of procedure due process doctrine.
But is this a difference between governing and war governing?
It is, and the thing that Matt is not dealing with, which we'd have to work out, is what do you do with all these Supreme Court cases that adopt precisely the distinction I'm adopting. But let's leave that to one side. Let's assume that we find a way to get rid of those cases, that we find a way to distinguish the political practice, and then we say, okay, procedural due process applies. Okay, I'm the policymaker for a moment. You're my lawyers. Tell me what process is due Mr. Al-Awlaki. Tell me how to afford him procedural due process. I can't give him notice. That will, in fact, allow him not to be successfully targeted. I'm not interested in hearing what he has to say because we already know what we think he is. We think he is the equivalent of an enemy general. And the decision-making process, well, I'm the policymaker. I'm deciding. I'm not giving this to some neutral decision maker. None of that was done when Mr. Al-Awlaki was killed. None of it. If you want to call the executive's internal deliberation process procedural due process, call it that if you like, but I object because it's not what we ever mean in any other circumstance. And it doesn't serve the values of treating individuals in the fashion that the Due Process Clause and its procedural aspect seeks to serve.
Well, I think, unfortunately, we really are out of time. And this is the proverbial, well, my students know I use this phrase a lot, this is a 3-beer conversation. And I hope that this has stimulated exactly the kind of thinking that Duke Law School hopes to do. And this is why I'm so grateful to the library and Professor Dunshee and Dean Dunshee for stimulating this, and Dean Charles for stimulating and having this event, because I hope that even if you don't agree with anything that's been said on either side, that you're better armed, and I would encourage you to, remember, it's only like this. You can get through this in the summer, to take a look at Professor Powell's argument and come to your own conclusions. Thank you.
And thank you all. Thank you.